Thanks to Skillshare for keeping Legaleagle in the air. Learn to think like a lawyer for free for 2 months by clicking the link in the description. The dominant counter-narrative against the whistleblower complaint is that it is hearsay. And the critics claim that the whistleblower complaint is hearsay is absolutely true. In places, it's actually double hearsay. But this probably isn't the criticism that you think it is. Hey Legaleagles, it's time to think like a lawyer because certain American presidents and certain Republican senators from South Carolina seem to have forgotten how to do that. Recently, Lindsey Graham and many others, including the President of the United States, are disputing the veracity of the whistleblower complaint and the readout transcript of the phone call with the Ukrainian president on the basis of hearsay. You can find many prominent Republicans going on cable TV and complaining that the whistleblower complaint is hearsay and therefore should be disregarded.
The whistleblower wasn't on the call. The IG, Inspector General, didn't read the call. The president did nothing in this phone call that's impeachable.
You can also find them on Twitter, basically recapitulating the same thing, that the whistleblower complaint and the readout in the transcript should be disregarded on the basis that it's hearsay. Lindsey Graham has gone so far as to say that you can't even get a parking ticket in the United States on the basis of hearsay, and that's somehow the basis for potential impeachment of the President of the United States.
This seems to me like a political setup. It's all hearsay. You can't get a parking ticket conviction based on hearsay. The whistleblower didn't hear the phone call.
Recently, the White House has been scrambling to counter the bombshell allegations of the whistleblower complaint and the Ukraine transcript. As an aside, when critics fight the process instead of the substance of an argument, it tells you a lot about the weaknesses of their defense. You might have heard of damning with faint praise. Well, this is praising with faint damnation. Well, first let's talk about the nature of hearsay. What is hearsay? Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that particular statement. Out of court just means it's not under oath and not made in the particular proceedings that are occurring at the time. And offered to prove the truth of the matter asserted is that you are relying on the veracity of the statement itself, as opposed to some other reason. So for example, let's say I testify in court that Will from Knowing Better said Legaleagle is the greatest YouTube channel that exists today. Now, if I were trying to prove the truth of the matter asserted that Legaleagle is in fact the best YouTube channel out there, then that would be hearsay because I'm using the truth of the matter asserted.
What does that mean? Basically whatever you want it to. There is no look.
However, if I am simply using that as evidence to show that Will has seen Legaleagle or that he knows how to speak English, that's not using the truth of the matter asserted in the statement and therefore would not be considered hearsay, despite the fact that it is still evidence of something that someone else said outside of court. Also, another thing that trips up a lot of people is that photos, videos, and audio recordings themselves are hearsay. They are recordations of statements that are made outside of court. So you need a hearsay exception if you're going to admit things like a video recording or an audio recording into court. As you're probably aware, hearsay is often inadmissible in court, but it's often admissible as well. It depends on the rules of evidence and it depends on the exceptions to the hearsay rule. It also depends on the tribunal. In fact, my understanding is that in many civil law countries, hearsay is always allowed, and whether the evidence is considered strong or weak is left to the trier of fact. There's no blanket rule that hearsay needs to be excluded. But in the American judicial system and the American tradition, hearsay generally is not admissible because you can't cross-examine the person who is making the statement. And you also can't check the credibility of the person whose statement is being elicited into court. Basically, it's a due process issue, more so than the common belief that hearsay is just bad evidence and should not be admitted. It's more about not being able to cross-examine the declarant. On the contrary, the rules of evidence in almost every state and the federal rules of evidence have tons of exceptions where you allow hearsay into evidence. American courts recognize that, like any kind of evidence, hearsay can be very strong or it can be very weak. It depends on the circumstances. That's why generally you would look for corroboration to the hearsay statement, or you would try and find counter evidence to the hearsay statement as well. There's absolutely no blanket rule that says hearsay is necessarily bad evidence and is not probative to the issue at hand. You can imagine a circumstance where a murder victim screams out, "Oh my God, Mike Myers is killing me," right before Mike Myers kills them, and that would be pretty good evidence that that person actually did the killing. But you might also imagine another circumstance where someone simply just makes up a statement that they claim they heard. It depends on the particular circumstance, and you have to take these hearsay statements case by case to determine whether it itself is strong or particularly weak. It's sort of like the difference between direct and circumstantial evidence. Often lay people say that circumstantial evidence is weak and direct evidence is very strong, where in actuality in the court, sometimes direct evidence like eyewitness testimony is actually very weak because people have false memories, they don't remember things particularly well. Direct evidence, often in the form of eyewitness testimony, can be extraordinarily weak. On the contrary, DNA evidence, for example, is 100% circumstantial. But DNA evidence can often be the strongest evidence that's out there. So just as the difference between direct and circumstantial evidence depends on the particular evidence at issue, it can be weak or strong, so too can hearsay be weak or strong depending on the circumstances and depending on the corroboration or lack thereof. And as you're probably aware, there are a lot of exceptions to the hearsay rule. In fact, the exceptions probably swallow the rule itself. It's actually kind of hard for practitioners not to be able to get hearsay evidence into evidence in court proceedings. In the federal rules of evidence, you can find the exceptions to the hearsay rule in FRE 801, 803, and 804. Some of these exceptions are called non-hearsay for some reason, so if it falls into the particular exception, it's actually considered not hearsay. I don't know why that distinction exists. Other hearsay exceptions actually rely on the declarant being unavailable, but in any event, if a hearsay statement falls into one of these exceptions, then that hearsay statement is admitted into court, and the fact finder is able to consider the evidence whether it's strong or weak. So since my practice often involves the federal rules of evidence, let's take a look at the most recent allegations and pieces of evidence under the rubric of the federal rules of evidence. Now, President Trump's incriminating statements to the Ukrainian President Zelensky are probably admissible on their face as binding admissions against him under Federal Rule of Evidence 801D2, which are admissions by a party opponent. In this case, a prosecutor would be able to use the statements made by a defendant, or in this case, the President of the United States, against them. In fact, Federal Rule of Evidence 801 is one of those sections that considers something not hearsay. So statements by a party opponent are actually not even considered hearsay in the first instance. And even if that wasn't the case, that Donald Trump was not a party to these proceedings, potentially impeachment proceedings, the statements would still be admissible under the exception to the hearsay rule 804B, which is a statement against someone's interests. The declaration against interest exception stems from the idea that if you say something that is against your penal interest, odds are you're probably being pretty accurate, because why else would you testify basically against yourself? Additionally, the things that President Trump is accused of, which includes extortion, bribery, and abusing the office of the presidency for personal gain, would almost certainly be considered legal acts. Legal acts are things that occur using statements that carry with them their own kind of legal significance. For example, if you thought about a written contract, well, those are just written words that are on a page, and as I said before, documents themselves are considered hearsay. But a contract is not considered hearsay because you're not using it for the truth of the matter asserted so much as the legal act itself of forming a contract. And the things that President Trump has allegedly done would consist of words that form themselves into a legal act. Like, how else would you commit the act of bribery, extortion, or abuse of power without using those words themselves? So in that particular circumstance, those legal acts would not themselves be considered hearsay. Apart from President Trump's statements himself, the readout or memorandum of the call between President Trump and President Zelensky would probably be admissible under a number of separate exceptions to the hearsay rule, including 803.1, the present sense impression, 803.5, a recorded recollection, 803.6, a record of a regularly conducted activity, or 803.8, a record of a public office. Business and government governmental records are often admitted into court using one or more of those exceptions. Some of those exceptions require you to show a certain chain of custody, but in this particular case, the White House released it directly and has admitted the veracity of the particular call, so I'm not sure that you would run into those particular issues in this case. Now, when you have double or triple hearsay, like when someone says he said that this other person said this other thing, you can admit that too, but you need exceptions for every level. So that takes us to the whistleblower complaint itself, which indeed would be considered hearsay, as any document would be considered hearsay, and it contains hearsay in the form of things that other people said. So in order to admit that into court, you would need to have an exception for both levels. And here, the first-hand witnesses are probably conveying a present sense impression into a recorded recollection, business record, or record of public office. So that covers those two levels. And to the extent that a witness is conveying something that President Trump said, to the whistleblower, that's considered triple hearsay, but again, so long as you have exceptions for each level, it would indeed be admissible. Here, President Trump's statements are both legal acts and therefore not hearsay, and admission by a party opponent, again, a non-hearsay / exception to the hearsay rule. Now, you can correct me if I'm wrong, but I don't think anyone is disputing that the whistleblower complaint would not be as strong as the more primary pieces of evidence that the whistleblower actually relied on. And as always, you would want to corroborate or disprove the statements of the whistleblower. And in fact, one such piece of primary evidence is the transcript itself. What's incredible here is that the whistleblower complaint is so close to the transcript. It's not 100% accurate, but it's damn close. So now that we have the readout of the Trump-Zelensky phone call, there's no reason to use the whistleblower's secondhand account of that phone call when we can just turn to the readout itself. And if the verbatim transcript or the audio tape of this particular phone call ever comes out, we'd want to use that instead of the readout. So it's absolutely true that the whistleblower complaint contains hearsay and double hearsay. It's all the more reason to talk to the Intelligence Community Inspector General, who did an investigation following up on the whistleblower complaint, or the first-hand witnesses that witnessed President Trump and President Zelensky either have the conversation or who witnessed other people cover up that conversation. And it's all the more reason to examine the documents that were generated as a result of this conversation and others, and that were potentially hidden in a code word secured database away from everyone else. So it's odd and perhaps a little disingenuous to focus on the hearsay nature of a whistleblower complaint when we already have evidence in the form of the transcript of the call itself that corroborates some of the allegations in the whistleblower complaint. So the whistleblower complaint is hearsay argument is probably not as strong as Lindsey Graham thinks it is. And it's absolutely inchoate in the context of the actual primary evidence, like the transcript. When the underlying evidence is out, focusing on the complaint is a little bit like the Wizard of Oz saying, don't pay attention to the man behind the curtain. Oh, and by the way, even if hearsay weren't admissible in court, which it often is, hearsay is used all of the time in front of grand juries to seek an indictment. Now, impeachment is not the same as a regular criminal indictment. We'll talk about that in a second. But notwithstanding, prosecutors get indictments using hearsay all the time. They're not bound by those same rules of evidence. But even if we were going to talk about the rules by which the Senate will conduct an impeachment trial, the Senate rules allow for the use of hearsay in an impeachment. It even went to the Supreme Court in Nixon versus the United States in 1993. That's not President Nixon, but a judge named Walter Nixon. And as you might recall, since history repeats itself, the last presidential impeachment was started by one of the most famous examples of hearsay in modern times. Linda Tripp secretly recorded her conversations with Monica Lewinsky as she talked about her affair with President Clinton. That was hearsay as well. So critics are right that the whistleblower complaint and some of the evidence contained therein is considered hearsay. It's just not the defense that they think it is. Now, if you want to learn how to make good arguments, or at least better arguments than Lindsey Graham, you'll probably want to brush up on your public speaking skills. I'd recommend Simon Sinek's Skillshare class, Presentation Essentials, How to Share Ideas That Inspire Action. It's a fantastic class from one of the world's great public speakers about making your next presentation unforgettable. Sinek helps you banish fears of public speaking and learn how to deliver effective oral presentations. 45,000 students have taken the course already and learned how to speak with conviction, master public public speaking, transform nerves into natural energy, and articulate what you really need to say in a public speech. Skillshare is an online learning community that has tens of thousands of classes on everything, like music, design, technology, and business. A yearly membership is less than $10 per month, but Legal Eagles will get 2 free months of Skillshare when you click on the link below. Plus, it really helps out the channel. The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things, all free for 2 months. So improve yourself now so you can start making non-hearsay arguments. Do you agree with my analysis? Leave your objections in the comments, and check out my other real law reviews over here, where I will see you in court, allegedly.